So in Utah, what happens if you die and you don't have a will? Well, every state has created what's called intestacy. In for not, testate, testate, having will. Without a will, intestacy. So what happens is there's a plan laid out as to who gets your stuff in the event that you die without having planned what to do with your stuff when you die. And it basically goes like this. If you have a spouse and children and your spouse survives you and all of your children are the children of that spouse gets everything. Second, if you have a spouse and you have children from a prior relationship, that surviving spouse gets the first $75,000 of your estate plus half of the rest, and the rest will go to your kids. If you die without a spouse or children, it goes first to your parents, then your siblings, and then off to your extended family. So, consequences of dying intestate. You have no control over what's going to happen to your assets. The court is going to say who gets what. It can be very expensive to deal with that, because if you're the last one to survive among you and your siblings and your kids, you know how many kids, it could be out to second cousins that a law firm and the court are going to have to track down to give notice to get your stuff. So it can really be expensive. Dying without a will or an estate plan creates a lot of conflict in families, because people will say, well, Dad said I could have this and Mom said I could have that. Well, no. If that wasn't in writing, in an estate planning document, a trust, or a will, the law governs, and what the judge says goes, regardless of what Mom or Dad may have told you at any time as things were going. So the other thing that a lot of people think about, if you've got minor kids and you don't say in estate planning documents a will who's going to be their guardian, the court gets to decide who's going to do that. So bottom line, make sure you get your estate planning done if you have these categories. Number one, if you have children, you've got to get a will done at the very least so you can name those guardians and who's going to have their stuff, so you don't have to go to court over that. Well, you might have to go to court, but you have control and say who does it. Second, if you own real estate, you need to get an estate plan done, most likely a trust, so that asset can pass without having to go to probate.